Time to study. Come on. Yes. DAIMAN developments never had against MATHEW, TECK, and ANOR. Ooh.
2,000 years later.
Oh. I have read this case, but I can't understand. Oh, I should go Zaha. Yeah, Zaha. You see here.
Later.
So the person making the proposal is called the proposer, offerer, or promiser. Proposer, offerer, and promiser. Okay. Looks like Ziha is calling me.
Hi Zaha.
Hello? Yes, Ziha?
What are you doing?
No, I'm just having my revision on the topic of proposal.
Are you free? Actually, I have difficulties to understand the case of DAIMAN development.
Oh, the case of DAIMAN development, right? Okay, I can explain it to you. But why don't we ask Faizah and Hana to join our discussion too?
Oh, that's a good idea. We can ask Faizah and Hana to join us.
Alright, okay. See you soon.
Alright, see you then. Bye.
Bye-bye. Can you guess what is the case that we are gonna discuss today? Yes, you are right. We are gonna discuss about the case of DAIMAN Development Syndrome Berhad versus MATHEW, TECK, and another appeal. Have you ever heard about this case? No? It's okay. We're gonna explain to you about it. So, this is a civil case that consists of appellant and the respondent. So, the appellant in this case is DAIMAN Development Syndrome Berhad, and the respondent in this case is MATHEW, TECK. This case had been go through in two courts, which is the first one is High Court and the second one is Court of Appeal or Privy Council, which is in Federal Court. So, this is the list of the judge who had heard this case. So, why is it contract law? This is because the respondent had paid $700 for the booking fee and signed a booking pro forma according to the both parties agreed that the purchase price of the house is $26,000.
A few moments later.
Subsequently, the appellants informed the respondent that the purchase price of the house is increased from $26,000 to $35,100. Why is it land law? This is because whether the appellants could subsequently increase the price of the house according to Housing Developers Control and Licensing Rules 1970.
The respondent had paid a booking fee $700 and signed a booking pro forma according to which the parties agreed the purchase price of the house was $26,000. The respondent also agreed that on receiving notice, he would sign the agreement for sale. The appellants, the housing developers, subsequently informed the respondent that the price of the building was increased to $35,100 because of amendment to the building plans and increase of material and construction. The respondent did not agree to the increased price and subsequently applied to the court for specific performance.
Later.
In 1972, the appellant owned a large area of land situated at Taman Sri Terbaru, Johor Bahru, which it proposed to develop as a housing estate erecting some 1,720 houses of various types, making provisions for roads and services for various community purposes. On October 1, 1972, the respondent desiring to purchase a house attended at the office of the appellant and there inspected the subdivision plan and the plans and a model of a semi-detached house which suited his purpose. He was satisfied with the location and dimensions of lot 941 and with the plans of the semi-detached house. He was told that neither the subdivision nor the building plan had been approved and that it would be some time before the construction of the house could begin. The respondent was prepared to wait for the necessary period and decided to purchase the land and the building. Having so decided, he paid to the appellant on that day the sum of $700 and received. Therefore, the appellants received the sum as the booking fee for lot number 941, single-story semi-detached. He also signed that day 2 copies of a document bearing the appellant's name and headed Booking Pro Forma. This was a document prepared by the appellant and apparently was in general use by it in connection with the disposal of lots in the estate.
I found another 3 matter facts from this case and I already jot down here, so I want to share with you guys. The first one, the lordships will refer to this document as the pro forma, and according to the statement of claims subsequently filed in the proceeding out of which this appeal arises, and the pro forma was signed by both parties. And in the appellant's statement of defense, it is not denied that the appellant did agree with the respondent in terms of the pro forma, though subject to conditions asserted by the appellant.
Soon after.
The appellant then required payment of a further sum of $2,810 together with the sum of $700 already paid, would provide a deposit of 10% of the purchase price. The appellant then proceeded to inform the respondent that if he failed to pay the further sum of $2,810 and to sign an agreement of sale at the increased price, within 14 days, the booking would be regarded as having been cancelled by him. That's cool. And the last one from my notes for the matter of fact is the respondent was not prepared at all to agree the increase in the price of the lot and the building, though he tendered to the appellant the sum of $1,900, which together with the sum of $700 would provide the required set deposit on the purchase at $26,000. And then the appellant rejected this tender and insists that it was not bound to sell the land and the building to the respondent for the sum of $26,000, though it was prepared to the effect a sale at the price of $25,100.
The legal issues in this case, firstly, whether there was a valid contract of sale. The next one, whether the parties have entered into contractual relationship with each other. Moreover, whether the developer subsequently can increase the price. Other than that, whether the booking pro forma is mere an agreement or not. Lastly, are the 4 conditions of agreements have been fulfilled by the both of the parties. What is ratio decidendi? Ratio decidendi is the most important aspect of a case. It comes from the Latin word that means reason for the decision. In the case of DAIMAN Development Sdn Bhd and MATHEW TECK are discussed in 2 courts, which are the High Court and Federal Court. In the High Court, the ratio decidendi are, in any case, there is no evidence or indication stated that the amendments required by the authorities, either to the subdivision or to the building plans, have resulted in a decrease in the number of housing units. that may be built on the land or the surrender of more land than was proposed and suggested in the original subdivision plan, or raise the cost of the building construction on lot 949. Judges also considered that the reason and explanation for the increasing price that was suggested by the appellants was not due to any other reason. This is because there has been a general increase in the price of the property in Johor Bahru region. Their Lordships will advise the Majesty, the Yang di-Pertuan Agong, that for this reason, these appeals should be dismissed with cause.
That's all from us. Thank you.